While we're on the court beat, the legal system has seen much improvements over the years. Various upgrades have taken place.
And as the Broadcasting Corporation observes 40 years in television, former court reporter Shelley Lewis joins us live in studio and shares some of her observations. Shelley?
Thank you, Michelle. Well, I had the opportunity over the past several days to visit the courts and was quite surprised at some of the many changes that I saw. Just take a look.
The courts are technology-driven. Plush settings compared to those days when the media fought for a seat at a desk that barely held space for two. The settings have changed much. The hard benches now replaced with comfortable seating. There is now video link and even a robe room for the attorneys. The lightings are also different. But with all the technology, the plush settings, and the improvement, there still remains an age-old problem.
Those problems still persist, even in the Court of Appeal, and almost on a daily basis. I've had to reprimand counsel about the kind of service that they are rendering to their clients. Very often a matter is set down for substantive hearing, and counsel would come on the day of trial and said, we need an adjournment because we have not been able to put in our submissions, or we need to amend the notice of appeal and we have not been able to do that. So that occurs on a daily basis, and I have had to reprimand, like I say, counsel almost every day about the service, the standard of service that they render to their clients.
And almost without fail, certainly in the United States and in the United Kingdom and in other parts of the world as well, you see a very high incidence of plea bargaining. In other words, most trials, most cases do not go to trial. In the United States, at the state court level, at the federal court level, 90 to 95% of their criminal cases are resolved by charges being withdrawn or being plea bargained. In the Bahamas, the exact opposite is the case. 90 to 95% of our criminal cases have to go to trial.
The role is now reversed for Supreme Court Justice Bernard Turner. The former Director of Public Prosecutions is now the Supreme Court judge. He knows the problem firsthand, and with 10 judges on the bench today, 52 weeks, 1 session annually, 20 judicial weeks, and with the simplest case going to trial, it takes roughly 1 week. The more complex cases, several weeks to a month. Factoring all this in mind, the task is still almost impossible.
We cannot really exceed that capacity. If the amount of matters coming into the system exceeds that capacity, however, we will continue to grow a backlog of matters until we get to the point in which matters are able to be effectively dealt with by way of plea bargaining. Now, the legislation is in place. It's used from time to time, but of course, every defendant before a court is presumed innocent and has a constitutional right, if he desires it, to have his day in court.
There have been numerous cases before the courts over the years, among them the many high-profile cases that went on for months, even years. Some of them include the Philip Bethel drug trial, 90 Samuel Knowles, Chuck Virgil, and John Higgs. And today it appears, regardless of the improved settings, the technology, the increasing numbers of cases going before the courts will continue to pose a challenge for the system. Michelle Ladorn, back to you.
Thank you, Shelley.